Hey guys, my name is Leigh Ann Webster. I'm an attorney at the firm Strickland Webster LLC. We are a criminal defense firm, but we mostly handle appeals and post-conviction matters. So I wanted to talk today about something called the motion for new trial. It's a little anomalous in Georgia. It is a weird procedural mechanism, I think, and so not a lot of other places have that procedure. So I wanted to talk a little bit about what that is and what you can do at the motion for new trial stage. I think a lot of people sort of discount it because you go back in front of the same judge that you had initially, and most often that judge is never going to grant your motion for new trial. That's just realistically speaking. It is incredibly rare for a judge who presided over the trial and who sentenced the defendant to say, you know what, that trial actually wasn't fair, so yeah, we're gonna do the whole thing over again. It almost never happens, although it has. People end up discounting the motion for new trial stage because they know that it's going to be denied. So it's actually a huge mistake to do that, right? So it is a huge mistake to totally discount the motion for new trial stage. I would actually argue that it is incredibly important and that for most of the cases you win or lose at the motion for new trial stage. It's not because of what the trial court judge says, it's because of the evidence that you get into the record at the motion for new trial. At the motion for new trial stage, that's when you can raise in Georgia for the first time ineffective assistance of counsel claims. And so that's where you can argue that either your attorney did something wrong or didn't do something that they should have done, or that your attorney did something wrong and they acted when they shouldn't have and that hurt you. And so the problem with ineffective assistance of counsel claims that a lot of people fail to recognize is that when you're alleging that trial counsel was ineffective, you actually have to do the things that you said your trial counsel should have done. So if there were witnesses that you think that your attorney should have called, if there were expert witnesses that they should have sought out, if there was impeachment evidence, if there was other evidence out there that could have helped you rebut the state's case and to prove your theory of defense, and it didn't come in, then all of that has to come in at the motion for new trial stage, or you are going to lose at the Court of Appeals. And so that is why your motion for new trial is actually hugely important, because you have to go out and do everything that you think your attorney should have done the first time. And if there are other pieces of evidence that would have supported your other claims, for example, if the trial court refused to let a witness testify, but you want to raise on appeal that was error, that the trial court erred by excluding your witness, then you need to have that witness generally come in and testify at the motion for new trial hearing so you can show what their testimony would have been like. There are some exceptions to that. For example, if your attorney made a great proffer about what that witness would have said, but generally speaking, it's best practices in order to bring that witness in and have them testify so there's no mistake about what they would have done. So again, if you're in the motion for new trial stage and you know that there are things that should have been done at trial that weren't, would highly encourage you to tell your attorney that and make sure that they are presenting all of that evidence at the motion for new trial stage, or otherwise you're going to forfeit your ability to really raise that issue in a meaningful way on direct appeal. If you are in the motion for new trial stage and you are looking for an attorney, we'd love to represent you and to talk to you about that. Please give us a call, 404-590-7967. Thanks. Bye.